And we're now live. So before we really start, I'm just going to give our viewers about 1 minute or close to 1 minute just to start to join us. And then we will do our welcome and introduction to get things going.
All right.
So welcome again, guys. We're just waiting a few more seconds before we start. All right. So we are going to start now. So hi guys, welcome to Stocks on the Rocks. Today we'll be talking about writing your will and all things related to protecting your legacy after the death. On call with me are our moderator and founder Simon Johnson of Stocks on the Rocks, who is joined by attorney at laws Jaavonne Taylor and Courtnay Patterson. I'll allow them to introduce themselves in a bit. I'll hand over to our moderator now, though, Simon Johnson, to get the ball rolling. Do enjoy the session, and please post all your questions in our live chat, and we will definitely try to cover all throughout the session. Simon?
All right, thank you so much, Trevor, and welcome again, guys. Welcome to Stocks on the Rocks, and we'll just get right into it. Courtnay, welcome. I just allow you guys to just introduce yourselves.
All right. Simon, thank you so much for having us. Certainly, it's a pleasure to be here. My name is Jaavonne. I'm an attorney at law. I've been in practice at the private bar for in excess of 4 years. My practice specializes civil and commercial litigation, primarily civil litigation. And in that regard, I do some general litigation matters in estates. And it's a really interesting area. And thank you so much for having me. I really hope it's a great session tonight.
Good evening, everyone. My name is Courtnay Patterson. I too have been practicing for in excess of 4 years. My practice includes civil and commercial law as well, insurance law, contracts. So, those are some of the areas that I specialize in. And I'm happy to be here with you all tonight, and we're ready to share and, give back to the community with our knowledge.
Yes, thanks again.
All right, so I'll just get right into it, Jay and Courtney. So, start us off with explaining exactly what's a will and why should I find it important.
All right. Well, simply put, a will is a legal document that pretty much you explain your last wishes, what you want to happen to your assets after you've left this earth, right? So it's basically a document that you spell out everything that you want to happen. You spell out, how do you want your host to be dealt with? Who do you want to get the host? Who do you want to get the car? Who do you want to have access to the bank account? Who will take care of the children? In the event that you go. So it is a document that basically survives you. So when you die, because death is inevitable, as we all know, this document is supposed to be there to take care of your assets and your estate, to how would you say it, Courtney, to basically improve or
Yeah, I would say it's an opportunity to rule from the grave, because you decide how the show is being run. If you want to be buried in a purple suit, you put it in your will. I want to put on my best purple suit. If you want your children, if you have young children and you want your children to be raised by this particular aunt and not this one, you put it in your will. If you have a home that you want to ensure that it goes to your wife or this brother, that is your opportunity to say exactly how you want things to be done. Because If you don't, the government has a way to an order in which they will distribute your assets if you don't do that.
And that's a statutory requirement, So if you don't dictate how it's gonna go, the government under the law will certainly dictate it for you. So that, simply put, that's what our will is.
So in that, Jay, I listened to you and Courtney's face, and you mentioned that that's called intestate, right? So if you die intestate, my grandmother always said intestate, but it's intestate, right? What's the government's order in how they distribute your assets if you die without a will, without stating what your wishes are?
Okay, so there is a table of distribution and an order of priority. Certainly, if you die and there is a spouse, so the spouse can either be the marital spouse or a common law spouse. And just for those of us who don't know, a common law spouse is someone who has been your partner for in excess of 5 years, like you are
living together
in the same home, man and wife. So that's where our law, man and woman, sorry. That's how our law is right now. So that's the first person. So the first person is the surviving spouse. Then we get to the children. If there are no children, then we look at the parents. If there's no parents, then it goes to grandparents. Then if there's no grandparents, we look to siblings. I think it's aunts, uncles, right? So there is a table of distribution as to how the estate will be dealt with if it is that you do not sit down and take the time to plan your affairs accordingly, right?
So Courtnay, does that involve any costs for my family, or do they pay that cost up front if there is a cost, or does it come from any assets that I have or don't have?
So it definitely will attract a cost. If you don't have a will and you need your estate to be dealt with, what you'll have to do is make an application for letters of administration. So in that instance, an administrator would be appointed, and they would then, transfer what needs to be transferred to the appropriate person. So it would attract a cost.
Okay, thank you for that, Courtnay. So effectively, if let's say I have a baby mother, right? We've been living together for 10 years, but me never feel brave enough to pop the question. So she's not my wife. So you're saying technically in the law, she's my common law wife, and if I die without a will, then she has first claim on my assets, right? However, if my intention were, let's say we're never really good, right? So to everybody else, we look good because we keep the relationship together for the kids. But I have an older child from a previous relationship that I would prefer my assets to go to. My assets will go to her first.
Yeah. And you see, this is why
ruling from the grave.
And this is why writing your will is so important, because you know the dynamics of your situation and your reality. We don't know that. So if you don't take the time out now to say, you know what, me and wife are really good, and I mean, yeah, I rate her to an extent, but I don't want her to get the bulk of my thing. You have to sit down now and structure it in a way to ensure that it's your eldest child that will get the majority. You understand? And then your other children will be taken care of as well.
In a little bit more detail, all right, so let me break it down for you. The surviving spouse is entitled to personal chattel, absolutely. So trying to read the comments, but let me just finish my thought before I get to the comment. Right, so you have a favorite chair or something in the home that you love and you wanted this to get to your eldest child outside of this relationship that you have. Based on the act, the surviving spouse is entitled to all personal chattel, absolutely. And 10% or $10,000 of the net value of the estate, whichever is greater, right? The entire remainder of the estate if there is no child or parent, right? After that, if there is one child in the relationship or marriage, the spouse gets 2/3 and the child gets 1/3, right? If there's more than one child, the spouse gets half and the children will share the other half. You understand? So it is really a detailed distribution. And so if you want to ensure that your child gets this particular asset that the spouse would be entitled to under the act, then you should make your will. As I say,
Uh,
rule from the grave.
The
yes, yes.
intestate estates and property charges are.
Mhm. And there's this myth around, the wills that you should really focus on when you're going to die when you're old. But we all know that a lot of people don't die when they're old. It's really something that you
Right.
should focus on as soon as possible from yesterday. So
Yeah.
Darcy is
And
asking, when is the ideal time to make a will? Additionally, what is an appropriate timeline to update it?
I will add, like, if we look on this space right now, there are children 6-year-old who making $6 million from YouTube. You understand? There are people who are 15 and 20, 25 who are making bank. You understand? And these are assets that we want to protect. Granted, you can only make a will if you're 18, right? 18 or over. So for the young YouTubers that are making bank, the ideal time is now.
Right.
You don't know when you will pass, right? But do take into consideration the fact that in Jamaica, when you are married, your will is invalidated.
All right, but before Courtnay goes there, just piggybacking on that, it's the moment you start to create, the moment you start having assets. So the moment you open a bank account, once you're over 18, the moment you open a bank account, make a will. The moment you acquire a car, make a will. The moment you buy real estate, make a will. The moment you have a child, make a will. And I'm going to say this too, even if you don't have any assets, but you have a child, right? To me, and I could be wrong, but I think it becomes even more important to make a will once you have a child, because you want to at least put some measures in place to say, in the event that I pass, Aunt Ruby or Uncle Joey will be in charge of, baby Jane, right? And your will can assist you with doing that additionally as well. And, sometimes we die in very bizarre ways. You could just be coming from Dream Weekend or something, and God forbid an accident happens, right? Mm-hmm. If you have a will with a duly appointed executor, those executors can actually commence a claim on behalf of the estate, right? For you. So if your estate didn't have any money before, but you had made a will and say, you appoint Courtnay and Jaavonne as your executors. The moment you pass away, and this will is executed in a valid way, right? Courtnay and Jaavonne as executors can bring a claim on behalf of the estate for you. So, so these are things to consider and to contemplate. So you may not necessarily have the assets right away, but
that's a good point.
These are things to consider, because I see so many accidents happening on the road these days. So many of us are losing lives just in the blink of an eye. And from somebody who deals with a lot of personal injury, I can tell you, it makes your life a lot easier if there is already a duly appointed executor to deal with it. Because if you don't have, a duly appointed executor, you will have to, depending on, whether or not there's a minor child involved in the estate, somebody will have to be appointed. The administrator ad litem to commence the claim for you, or if there is a child, then the administrator general department will have to get involved and issue an instrument of administration, and then they will have to step into the shoes of dealing with the estate. So there's a lot of things to consider.
So what you're saying is that the ideal time is now, and the timeline within which you should update that. So firstly, if I create a will last week and I buy a house this week, does that house become a part of the assets that are claimed by that will? Or do I need to
Well,
update
it depends on how you draft the will. It depends on how you draft the will, because, all right, so you make a will today, and at the present, you have a car, you have several bank accounts, and you have an investment account. And those are what you've listed in the estate, listed in your will, right? But next week, like you say, you buy your house. How we would structure it, if, as attorneys, and how we usually structure it, we put what we call a residuary clause in the will. That way, every time you go and buy a new asset, you don't have to keep updating the will per se. If it is that your beneficiaries would not, change.
But I would say if you wanted the house to go to a particular person, then you would have to update the will.
Right.
Because sometimes the residuary clause, you probably just leave. Let me explain what it is. So when you assign all of your assets to the particular beneficiaries, the residuary clause is a clause that allows anything that you may not have caught and specifically named in the will, it would go to that person. So it wouldn't fall outside of the will, and you wouldn't have to do get a letter of administration with will annex for that. But if you want to give the gift to a particular person, then you'd have to update the will. I'll also add that, as I said, if you're married, the will is invalidated, you have to do it over. So those are things to consider as to when you would want to update your will.
Right. And of course, reality is so things will change. So today, Courtnay and I are best of friends, and I love Courtnay, and I want Courtnay to inherit all of my estates. And then tomorrow, I hear that Courtnay chatting me to people I don't like, and I don't want Courtnay getting nothing.
Yeah.
So I'm going to change it. So again, your circumstances will determine how often you change your will as well, right? Because you've heard the story of people writing people out of their wills and changing wills because some child never do what the parent wanted them to do, so the parent disinherit them, or some child turn out to be abusive to the parent, so the parent turn away. So, you can update it as often as you wish. That's the truth. But, again, your circumstances determine that.
So Jaavonne, Courtnay, I know that lawyers are typically wealthy, because you charge those hefty fees.
I really wish you guys would stop saying this. Well, certainly, let me speak from my experience. I'm not wealthy, but
speak it into being.
One day.
I'm speaking it into being. Into being. But P things here says attorneys typically charge about 3% of the estate. So I wanted to confirm that. But if the estate just has real estate as assets and not necessarily cash to pay, is it that, Jaavonne, when you've gone through my process, or if there needs to be a probate process, for example, will I have to sell a property to pay you, or how do you collect those fees?
So it really depends. P things has mentioned 3%. Yes, you've heard of. So typically estates are done doing a percentage basis. Sometimes depending on the size of the estate, some persons will charge a flat fee. I know of attorneys who, if it is like it's just one house, they will charge a flat fee for that, because they realize it's one estate, one asset of the estate, and the estate is not liquid, right? And like you said, if the estate only has just a house, is it a situation where that house has to be sold to pay my fees, right? So those are some considerations. But in general, it is charged on a percentage basis, and the percentage ranges anywhere from 2% all the way up to about 6%. Again, it depends on the value of the estate, how complicated the estate can be as well, because at the end of the day, I can't tell you here. I can't just, tell you, oh, all right, Simon, come to me with a house. I'm just gonna charge you 2%. I don't know. I'll have to see what it is first before I can say, all right, this is what my fees are gonna be. Typically, how fees are paid, the executor usually has the responsibility of upfronting that money, right? The executor or the executors, they're usually the ones with the responsibility of upfronting that money. You have some estates that are liquid, right? And some testators in their will say that my money at Sagicor Bank, let's say, for example, at X account, the money here should be used to pay for my legal fees and to assist with the administration of my estate, right? Yeah. You have some persons who expressly say that. Some persons will have livestock, cattle. They will say, these must be sold to assist with the legal fees. But if you don't have that, what typically happens is that the executor is the one who upfronts that money, right?
Okay.
So these are some considerations.
And so as it pertains to the costs and the estate itself, so you're saying that the executor has a responsibility to upfront the associated costs. If it's small, so it depends on what, because I've heard of, for example, a case where the great grandmother was gifted the land, so they've never had any title for the land. She had 15 children, then she had 30 odd great grandchildren, 50 odd great grandchildren, and my parent is the 6th of the 9th great grandchild. So I am way, for example, way down the line.
Mhm.
So for me to come to Jaavonne and say, hey, I think I have a claim to this 300-acre property in Portland, I know that you are going to probably have to do a whole heap of work just
Tracing.
to
Yeah,
Listen,
come.
man.
you see that tracing. That tracing thing is so important. And then you mentioned a very key ingredient right there. You just said this land don't have no title.
Yeah, that's headache.
So that's another problem.
Seek legal advice, please.
Right. So you see that's another conundrum unto itself. But that's a reality that we face here in Jamaica because we do have registered and unregistered land. Right. So
Mhm.
with that, you just described what I call one of the scenarios that are not very straightforward.
Yeah.
And so for a matter like that, you are
Mhm.
definitely going to be charged on the higher end of the scale.
Yeah.
So Jaavonne, you said tracing. Give us a little more detail as it pertains to how do you go about that tracing process? Is it that you go on the NLA ELAN website and you just download what information is there, and how do you do it?
Well, all right. So to be honest, it's a very involved process. So because so you're gonna have to be tracing the bloodline. That's basically what it is. So you now come to me and you say you're the great grandchild of Queen Elizabeth, right?
Prove it.
You have to
Right.
prove it.
Right.
Right. So we have to get birth
communities
certificates,
and-
so you have to give me the birth certificate and we have to say, okay, so you are the son of King Charles, and then this that, you understand, and then King Charles is the son of Elizabeth, and we have to go through all of that. And again, Courtnay highlighted a good factor. You also have to go into the community.
And because Auntie May might say, yeah, man, I know that King Charles owned this land. He was
Wow.
on the land for 20 years. And, so you have to get people to be able to corroborate.
It's a very
You have to be a detective.
process.
Yeah.
So you have to be a detective. Then you have to put together all the facts of the.
And I'm happy you brought that up, because before coming into law, I didn't realize how many hats you have to wear. But certainly that detective hat comes in very useful. My co-workers will tell you I am like the investigator or the private eye, because I have to be digging up and looking for people all the time.
Yes, yeah. And then I guess another challenge that we'll have that is not necessarily unique to Jamaica, but it's very common, is where one, names are spelled incorrectly. Some people don't have birth certificates. So technically the evidence that you're looking for, a lineage or the bloodline, might not even exist. So it might just be the oldest person in the community that can say, oh yes, that definitely was him cousin and that was the uncle, and
So exactly. So that in and of itself is very, it's a lengthy process. I see someone commenting here and say that would be way too much work. It would be better to just go and buy your own land instead of just trying to.
problem.
It
And I want
happens.
to tell you,
It happens. It's very problematic.
I've spoken to people that say, boy, I know my grandma have land over here, but I just can't bother. Make them go on with it, because the amount of work and fighting that I'm going to have to do.
And you see, this is, again, and you see, it all ties back. So had grandma at the time sat down and made a little will, and to say that my land with my 300 acres of land here, I pass it down to my children, at least it would assist better in the tracing process, because even if she don't name all of her children, we know who the children are, right? But what happened, you don't have a lot of this happening. So it's a he said, she said kind of thing. And this is law, we deal with facts. So it's going to be a very lengthy and very involved process.
Yeah, I want to touch the question on the screen and then move on to what can I do now to pass on my assets even outside of the will process. So firstly, who reviews the will?
I'm pardon me, I'm not sure if I understand the question, but if my interpretation of the question is this, in terms of reviewing the will. So if you go to an attorney, for an attorney to prepare the will, the attorney will know how the will is supposed to be prepared, and ensure that the will is prepared in accordance with law, and ensure that the will is duly executed in accordance with law. When the person dies, that's the testator. When they die, the will is typically brought to an attorney who will review it at that time, and then they will send it for filing in the probate division of the Supreme Court or respective court, right? Depending on the value of the estate.
How does it work when I know they have the wills in pharmacies? How does it work with
We
that
have one
one?
here actually.
Oh, you have one? Yeah. How,
Yeah.
is that one already reviewed and legal? How do I know that that's a legal?
Okay, so I love that you went there because we wanted to go here too. So a lot of persons are of the view that when you buy this, the moment you buy this and anything you write on this makes it a will, right? So I'm here to tell you that that's not the case, right? So yes, if it is that you execute this will in accordance to the law of Jamaica, then it will be valid. But if you do not follow the instructions, and trust me, there are actually instructions on this will. I don't know if you can see it here.
Yeah, man,
right?
I barely, but yes.
Right. So there are instructions on how to execute this will and how the will is to be valid, right? And how the will is supposed to be dealt with. But many people, in true Jamaican fashion, we buy the thing, we see that it says this is the will, and we believe that anything that we write on this will form makes it a valid will. And that's not the case. So yes, you go and pay $250 in Kingston Bookshop or in Sangsters or in the pharmacy and you buy this, right? And you say, all right, I'm making a will. And you sit down and you basically scribble, all right, I have my house, I have my car, and I'm leaving them to Courtnay and I'm leaving them to Jaavonne. But you don't appoint an executor. You don't sign the will in the presence of two witnesses.
There's no residuary clause, because I just checked, and that is one of my favorite clauses in the will. It's so important, you know. It's not there, so you take a risk when you decide to go and purchase this $250 will and say you're gonna do your own thing. I would say just do it right, you know. Get some proper advice.
Right. And I know we always run away from money because everybody love to say lawyer make money, lawyer rich, and lawyer charge too much. But let me tell you something. It's better you spend the money up front and do it right, because when it is done wrong, you know, you're going to spend more money.
Yeah.
Because it's the same lawyer you were running away from in the beginning that your family will have to run to in the end now to try and sort out your affairs.
Yeah.
You understand? So whilst it is that you can use this, you can use the will form to create a will. And if you read it, it does say that if you have very if you have limited assets or if it's very straightforward, small things, you can use the will form. You have to ensure that it is done in the proper way.
Yeah.
So you have to sign the will in the presence of two witnesses at the very least, and they have to be present at the same time. You need to appoint an executor. Now, we recommend at least two, right? The persons who are witnessing the will should not be beneficiaries to that will. You understand? So there are certain things that you definitely need to be able to appreciate before you take on the task of drafting a will yourself.
Yeah.
Courtnay, suppose I don't want nobody to know when me I think about my intentions after that. And I come to you, I draft a nice fancy will, all the assets, the residuary clause, all the rights clauses, etc. And I come home and put it in a deep, dark corner. Does it exist?
It only exists if we can't find it when we need to find it.
I mean, it exists from the moment you execute it. That's true.
But if we can't find it, and we were just talking about this today, if you have your will, it's beautiful. With Jaavonne or myself, we drafted your will, it's beautiful, and you're gonna lock it up in a safe that nobody can access. You understand? What's the point of it? You understand? So, I mean, you don't have to let your beneficiaries know that you have drafted the will and that they're getting the house or they're getting the pretty BMW. But at least, let somebody know where to locate the will.
And what I've seen people do, especially if they have the attorney that drafted it, if they have a relationship with that attorney, sometimes they leave the will in the care of that attorney.
Yeah.
Sometimes they leave the will in the care of the executors. Right? And they say, this is my will, I want you to keep it. Or what I've seen persons do as well, they will give a photocopy of the will to the executor and leave the original will with the attorney, right? Or if you don't want to leave it with anyone, certainly you can put it, keep it in your safe at home, keep it somewhere, but The crux is that when you die, we need to be able to find it.
Yeah.
So Jaavonne, so when you're Queen Elizabeth and you have a lot of assets to pass on, the attorney knows when you die, right? It is known. So let's say I am one of your many clients. You don't know when I die. I leave my original and only copy with you, and nobody else that is close to my family is aware of it. Is it that there is some record somewhere that I created a will that they can check, like an office in the government somewhere?
All right, so you can actually record your wills at the RGD. It's not mandated, but there is a service offered by the Registrar General's Department where you can actually register the will there. Another thing that I know happens, as I said, that, and you mentioned it, this is a good point. Some persons, they will just tell, like a friend, to say, if I die, call my lawyer. She will tell you what to do, or he will tell you what to do. And so you will find yourself sitting down in your office going about your business, and you get a phone call to say, John Brown has passed away. And the moment you hear that John Brown has passed away, you're going to start going through, you go for the file because you know you have the will, and then you'll make contact with the executor if it's not the executor that contacted you. Certainly, you wouldn't want to make contact with a beneficiary before contacting the executor, right? Because the executor is the one who has the responsibility now of administering the estate.
I've always wanted to ask, is there a fancy will reading? So like when the movies, all the family members get called in a room.
It's funny. We see that on TV all the time. We do, and there's no requirement here for it. Persons do it, but there is no requirement. If you want to be dramatic, me personally, let me tell you something. When people die, that is when they get all of the drama and all of that. And will readings, in my view, sometimes you have those will readings, and that is where the fighting starts. Because I'm saying, how you get more than me, and why you get this, and why I don't get that. And, It's not necessary, but at the same time, if a testator writes in his will, I want my will to be read, then the executor really and truly should follow suit. Or if the executor chooses to have a will reading, then go ahead.
I'll ask one more question before we go on to the question from Stephen. Guys, I see your questions. I'm going to go through them now and get some sharp responses from our counsels. So you would have started explaining the process before. Stephen wants to understand so Stephen dies today. He has a will. God forbid, Stephen. He has a will. What's the process?
All right. So the process is the will is taken to the lawyer. That's first. We look at that will, we review the will to make sure it is a valid will. Having realized that it is a valid will, you will apply to the court for the grant of probate, right? The grant of probate, so if once there are duly appointed executors on that will, then they will swear this document called the oath of executor, right? And they file that along with a copy of the will in the probate division of the Supreme Court. And then that process, it takes anywhere, it depends, because back in the day, it used to take a very long time, but we have seen in recent times where once there is no error, you're seeing, you can get grants in 6 months, you can get grants in 8 months. And I have to actually say big up to the Supreme Court of Judicature.
Hold on, Jaavonne.
Because they have been doing
6 months is short.
I'm serious. But here, that's just step one, That's just step one. So that's just the grant of probate. Right? Because remember, the grant is the document now, the official document that gives the executor the power and the duty to deal with the assets as if they were the testator. Yeah. Right? So the will is just the instructing document as far as I'm concerned. And then you use the will as the instructing document to get the official authorization from the court, which is the grant to say, all right, Jaavonneztaylor, Courtnay, Patterson, executors, you can now go and deal with the estate of John Brown, right? So that's step one. Want to do it step two?
Go on.
All right. So, why you do this to me? All right. So after that, so that's step one. You get your grant. After you get your grant, the next step is to calling the assets, their assets. So what assets do the estate have? If this is a very nice, very good will that tell you everything about the assets, you say, all right, we have bank accounts at JMB, we have bank accounts at Scotia, we have bank accounts here. We call in the assets, we do all of that, right? And then of course, because you need to now know the value, what you would have had to estimate the value of the estate before applying for the grant, because duties for filing, there are different tiers of duties depending on the value of the estate, right? And of course, you know, you have to pay estate taxes and duties and that kind of thing. So the value of the estate really is important. You fill out a revenue affidavit, right? You apply for, the executor will apply to be registered on transmission, right? So it's a very involved process.
It's a lot.
Yeah, it's
But
a
this
lot.
is
That's
why
why
you
we
need
always
an
go
attorney.
to an attorney that can assist you.
It's
because
a
lot.
very involved process. And then after you're registered on transmission, then you have to deal with the transfer to the beneficiaries. So the registration on transmission is the testator, meaning the deceased person, their assets being transferred to the executor. And then the transfer process is where the property is moving from the executor to the beneficiaries, right? You have some beneficiaries too who say, listen, I don't want anything. So they want to disclaim their interest as well. You do have persons like that that say, listen, I'm not interested. I don't want that.
Wait, people are doing things and you say, you know, and then people say,
best believe. People do that, you know, for whatever reason. People disclaim interest, and so there's that. So it's a very involved process. So you deal with the court, you deal with tax administration, right? You deal with titles office,
NLA,
because if there is titles, you deal with the banks. You know, you deal with different institutions. So it's a very involved process. So when people look at fees and say, oh, lawyer, thief, and this and that, listen, let me tell you something. You may not sit down and recognize how much work goes into this, you know, because remember, let's say, for example, I charge you 500,000 to deal with an estate, and this is not an actual cost. This is just an example, guys. So don't quote me, please. Right? I charge you 500,000, and it takes me a year to deal with this estate. 1 year. You divide 500,000 by 12. Right? Divide 500,000 by 12. When you divide $500,000 by 12 months, because that's the amount of time I'm spending on your matter, you're realizing that, but wait, that I not make no money, because the amount of work that you have to do sometimes is so much. But persons are looking at, oh, the lawyer, your TFE, I just want like a piece of paper they must sign, or it trust me, I promise you, it's not just a little piece of paper. So, it's very involved. And if there are issues as you raise with names, because some people names spell wrong on some, like on some documents, and there are different issues, right? TRNs are required for everybody. Suppose some of the beneficiaries don't live in Jamaica and they live overseas, and they need to apply for TRNs, right? Because that is a requirement now. So you have to, either they're going to do the application themselves, or they're going to authorize you to do the application on their behalf. You know, you have to ensure that the ID that they've sent matches the signature, rather, on the ID that they've sent down matches the signature on the authorization form and on the application. So it's a very involved process.
So quick question before I go back to the expenses. So we have a few questions from Shani Bud about that. But usually when we see the holdings of investments accounts, and when I say the holdings here, it's the public ones, so like the top 10 that is reported, we may see the estate of John Brown. When is it that name changes? Because before it was John Brown. So how does the account change to the estate of John Brown?
Well, it changes to the estate when John Brown dies.
Passes, yeah.
Okay, so once a death certificate is sent to the exchange, and okay, all right, fine, that was quick. So you had mentioned that the executor is responsible for certain fees up front, right? What if, and in a lot of cases, what if they just simply can't afford it?
Well, trust me,
family will have to determine.
Sometimes beneficiaries, what I have seen, and it happens a lot, the beneficiaries upfront the money. Because at the end of the day, if you're the one going to get the benefit, ultimately you don't want the estate to be stalled. So it's in your best interest. A lot of the times the beneficiaries will be the one upfronting the money. So that's something that you've seen. And if the executors can't afford it, I've never seen this personally, but I've heard persons say that executors sometimes take loans, to assist with the administration of the estate. I've never seen it, but I've been told it happens.
Okay. Yeah, man. So I have a question on screen from Shani Bud. I'll just read it for the benefit of everyone. Isn't it better to appoint a joint account holder beneficiaries to your bank accounts while living? Would a will still be needed if that is done?
All right. So this is a brilliant question. It is better to appoint a joint account holder to the account as opposed to putting it in your will, because an account, once, if Jaavonne and I are on an account and I pass, the money goes to Jaavonne automatically. It will not form part of my estate. So, and I hope it's something we get to delve into, shortly. But there are other ways to structure your estate, that you can avoid the fees.
So Courtney, talk to you. Talk to
All
you.
right,
Very high level. Very high level. Because we want to save some money as well.
All right, good. So this is my favorite part when I do these presentations, because young people, we're coming up, we want the tea, right? So joint accounts, that is something that you can use to pass on your assets without the need to have a will, right? We spoke about that. Life insurance policies. Now, this is a perfect tool that you can use to also pass on assets. And you can also build wealth. I know, I'm sure, Simon, you've spoken about this before. We're young people. We need to be thinking about leaving wealth for generations, right? And a perfect way to do that is through a life insurance policy. Once you name your beneficiary, the funds are automatically transferred to them. It does not fall part of
death.
Right. Once we can ascertain that you have passed, the funds go to your beneficiary as you have allocated. Titles, property. If you buy a property and you have a single mother and you want to make sure that she will be able to go on after you pass, put her on your title, because that saves you so much money. You can transfer, love and affection, transfer a portion of it to her.
And if you do it jointly, certainly all you have to do is do an application to note the death. So if you're joint tenants on the title, the right of survivorship would kick in. And so if you pass away, that person essentially, that interest is theirs, that entire property now falls to them, and all they will have to do really is pay for the application to note the death on the title that Mary Jane died on December 1, 2020, and so who is left now is John Brown, so the property now rests wholly in John Brown.
Right.
Now, obviously, there are risks to doing anything like that because, again, remember, especially on the joint account, so Courtney can have $20 trillion and I don't have $0 in my name, The minute I realize that Courtney put my name on a bank account and it's joint, I can draw out all of it. Yeah. And Courtney cannot say anything to me because we own that account jointly. Yeah. Right? So these are some things that you can actually put in place, right? So that it doesn't have to fall into your estate. And Courtney is definitely the best person to speak to that. I think, so it's something that we can think about. We're getting older now. Some of us are starting families. Some of us are getting married. These are just some of the things that we can do, some of the tools that we can utilize, in basically planning ahead and planning for the future. Another thing I will say, and the reason for me why I did this presentation, or did the Twitter space, I remember seeing an Instagram post a couple of years ago, and it spoke about the fact that African Americans and Africans are always starting over. They said when you compare us with other ethnic groups in terms of the generational wealth and the legacy, we are behind, right? And when I saw it first, of course, I was in my feelings a little bit because, I'm a black girl and all that stuff. But then I thought about it. And I'm saying, it's true. Because we will meet Caucasians or Indians or, persons from other ethnic groups, and they've inherited a wholesale from their father. They've inherited a car. They've inherited a business. They've inherited something. And you always find that, well, not always, but a lot of the times you find that persons of our complexion are starting over from scratch. Why is this the case? Because we're not utilizing the tools that are readily available at our fingertips to pass the legacy, to build the generational wealth. Why is it that you work so hard in your life now, Simon, and you build all of this, right? And when you go on tomorrow, somebody have to scurry and run around and try to access what you already built. Why is it that your friends or your children or your family can't just benefit directly so they don't have to start over from where you had to start? These are some of the things. We need to get out of this mindset where, oh, I struggle, so you have to struggle too. Come on. It's about building each other up. So I work hard now, so I'm going to leave a legacy for whomever I choose. So it doesn't have to be your children, It can be anybody. It can be a church. It can be a school. It can be anybody that you can leave a legacy for. But why would you work so hard in your lifetime to have all of that work in vain? We're going to die anyway, So why not let your hard work pay it forward to somebody else?
Man. We have a question on the screen. Courtnay, are there any circumstances under which a will wouldn't need probating based on its contents?
Interesting question.
That's an interesting question. I mean, not to my knowledge, if the contents of the will are there, you will need to have it probated so that it can be rightfully transferred to you.
Unless you're gonna say that all the gifts have failed or the gifts have lapsed, or
I mean, if I'm answering it high level, I would say yes, you would need to probate it.
Okay. Jay's asking, do you ever advise people to establish a trust instead of doing a will? What about trustees? Is it better to appoint a professional trustee instead of a lay person? And I guess this is one of those tools that the wealthy, or as Jaavonne said, the knowledgeable, because it's not just people that are wealthy, use to protect their assets from certain claims. Do you advise people to do trusts?
I mean, your circumstances differ. Everybody's circumstance is different. So certainly trusts are a very useful tool, in terms of building generational wealth and doing that. Some persons do both wills and trusts. It really just depends on you. And again, it depends on the size of your estate and what assets you have, right? So there are different factors that come into play when you are considering what tools and what options are available to you. In a will, persons do create trust because there's something called a life interest. So let's say, for example, Simon, you're married and, when you pass, you have a house in Cherry Gardens, right? And you say, for the remainder of my wife's life, I allow her to live in my home at Cherry Gardens. But upon her death, that house, it goes to Courtnay. That is a trust in and of itself because she's not the legal owner of that house, right? The legal owner will be the person who is going to get it at her death, but she has a beneficial interest in it because for her life, she will be able to live there, right? So there are certain things that can happen. So people think about trusts and wills separately, and yes, that really is the case, but you can actually create a trust in a will as well.
Courtnay, one of the things that I've heard, though don't quote me on it, is that for some people they know that the administration of their after probate process after death might be expensive. So what they do is they take out a life insurance policy and pay a part of their estate or assets in the premiums every month, and effectively their beneficiaries get that transfer on death, which I'm told is a bit easier than the probate process and a bit faster, and then they can use that cash and administer the entire process. Is that is it a more tax efficient way of passing on wealth?
Simon, you want to get me in trouble. I don't want to ill advise anyone, but I will say that people, there are different ways, there are different things that people can use to definitely ensure that the estates can be administered. And yes, life insurance policies can be used for a myriad of ways to ensure that you're able to fund this.
Right.
Okay. Aristotle phrase asking, I was told that the first 10 million will not be taxed. Is that true?
For transfer tax, yes, they're exempted. For estates valued at $10 million or less, you're exempted from that 1.5 percent tax. But you'll have to pay stamp duty if the value of the estate is under 10 million. Then you pay $5,000. If it is 10 million or above, you pay 10.
Okay, so there's some protection there. So I guess the law there assumes that if you are wealthy, for those that may have a problem paying for the administration of that part of the process, the estate is likely to be less than 10 million, and as such, there is some benefit
Yeah.
to that. Adrian is asking, what happens if a person dies while waiting? So Jaavonne, you had mentioned that 6 or 8 month period after the submission of the will. So this is the beneficiary, I believe.
The beneficiary or the executor. Because
sorry, the executor.
All right. So this is why we say have at least two. Because so if you have two executors, it really assists with this. Because if one of your executors pass, whilst it is that they're waiting for the grant, then the other executor can actually step in and get the process, continue the process rather, right? Because you will face a very unfortunate situation if both of your executors are gone at the same time. It's not that your matter can't be dealt with, but you would have to go the route of what we call letters of administration with will annexed, meaning because the executors who are the duly appointed persons under the will cannot take over and administer the estate, the person now, and we usually recommend it going in the same order of the table of distribution. So we would say, all right, like the spouse or the children, once they're adults, if that is the case, based on the same order of priority, if that person administers it, then they will have to annex a copy of the will, and then they would have to explain why it is that they are the ones doing this process. So it's always better to have at least two executors. Another reality, even if the other person doesn't die, remember, we live in a very dynamic world. So at present, you're drafting your will. Simon lives here, Courtnay lives here. But let's say you die in 2045 and Simon now live in Australia. Simon don't want to fly from Australia to come and deal with the estate in Jamaica. So Courtnay can apply for the grant of probate and reserve the power to Simon. You understand? So these are just some of the reasons why we say, guys, don't just use one person. Always try to have two.
Yeah.
Okay. So we have a little under 9 minutes. I want to take some questions that were sent in through our Telegram group, and just for our audience and our guests, we have a Telegram group with over 1,900 people, and within that group we discuss finance matters almost on a daily basis, just generally wealth, and this will be one of those this discussions this week, of course. So the question starts, I quote, what I want to know is, are there any non-traditional ways to execute a will? Let's say I sent myself and an executor that I choose an email with instructions on how to manage my estate in the event of something. Can the executor say, hey, Jaavonne sent me an email?
No.
No, and the reason for that, remember, look at the world that we live in, Simon. The obvious reason. Look at the world we live in. Every day people are becoming more and more intelligent in terms of using computers. Can you imagine somebody hacking to your email and say, they say, all right, all this estate is going to Courtnay Patterson, but it's under the guise as you. So, it can't work.
Serious business. This is serious business.
It has to be physically witnessed. That's why it has to be
and it has to be witnessed by two persons present at the same time.
And remember, there's legislation around this, It's not just we decide, we get up and we want to say two people must do this at the same time, and this is law. So no, in short, no. And we advise that so as not to run into any problems, just adhere to the requirements.
And wet signatures, guys, wet signatures. I know we're in the digital era with this e-signature. No, wet signatures.
Yeah, man, I know the government generally deals with wet. And so for everybody, wet here, me have to sign it with a pen. Yes, a pen. All right. So another question is, if somebody is disabled or mentally ill, how do they go about passing on their estate
Good question. All right. So I will take disabled and I will leave mentally ill for Jaavonne. All right.
I can't believe this.
So there is a clause called a marksman clause that would be included in a will and any document that requires the person's signature. All that marksman clause says is the will has been read over to Courtnay Patterson. She understands the content, she agrees to the content, and she can place her mark on the document to say yes, she agrees. So when this document is sent to the court now, the court would not expect a fancy signature because obviously the marksman clause has indicated that the person is blind, they can't sign, in the normal way, but the court has assurance that it has been read over to them and they understand. So in that case, the marksman clause would be the perfect clause to include in that situation.
Right. And now dealing with mental capacity quickly. So the reality is, if you are mentally incapable, then that will would not be valid, right? That is the general rule. So if you're non-compos mentis, meaning you're of unsound mind, if you read the will form, it says idiotic or lunatic, right? You are disqualified from doing that. And the general reason is that you wouldn't even be able to understand what it is that you are doing, right? However, there are some cases that the court has decided where if the person at the time, so even though that person is known for being, mentally incapacitated, let's say the person has dementia or Alzheimer's, if at the time of giving instructions to the attorney, they were of sound mind and they understood what they were doing, and at the time of signing the document, they knew what they were doing, then and only then in that limited circumstance can a mentally incapacitated person execute a document. Let me tell you though, that is not going to be without headache, because what you would have to do, you would have to try and include a clause there that a doctor was there at the time of signing this will to say that Mary Jane, though Alzheimer's patient, at the time of executing her will, understood that she was executing her last will and testament, and understood that these were the instructions that she gave her lawyer to be done. That's why, guys, that's why I said execute your will now. You see why when you're okay now, when you're of sound mind now, deal with it now, because you never know what can happen,
Yeah.
So it's best to do it now.
What I keep getting from, so we can go through 1,000 scenarios, right? Of this, but what I keep getting is that this is why one, it's important to start when you're okay and normal of right mind, and two, it's important to have a professional on your side that can properly advise you as to what should be done. Guys, we have a lot of questions, but we might have to do a part two. So let me just go through them. What about real estate that is owned by a husband and a wife? Does that need to be included in a will if the intention of both the wife and husband is to leave the real estate with each other?
Well, if that is the intention, hold it jointly. Hold it as joint tenants. If that is the intention, hold it as joint tenants and not tenants in common. Because if you hold it as tenants in common, that means both of you are entitled to individual shares, right? So it's individual shares. If you own it as joint tenants, it means both of you collectively own it together.
So if one passes, the other one gets it.
Hold on. Yeah, man. Go over that one there with me again. So you have joint tenants and tenants in common. So joint tenants is we both own the property.
Collectively, together. Yes. So there is no separation as to what portion is yours and what portion is mine. So all of the property belongs to Courtnay and Jaavonne exclusively. There's no demarcation.
So what's tenants in common?
There is a demarcation.
Oh, so I can own 60% of a property.
Whatever percentage you decide.
Oh, all right.
They can own it 50-50, 60-40, 70-30.
Okay, so if I have a sneaky link, so more than one sneaky link, I can give one 5%, another 5%, and somebody else 10%.
Well, I hope you wouldn't be giving your sneaky link a share now, so that you have with your wife, sir.
Messy.
Just saying.
But yes, you can absolutely do that. And what it means is that if Jaavonne and I hold it as tenants in common, and I pass, my 50% goes to my estate, and I can pass it to anybody that I choose.
Yeah, Michael is just agreeing that it's a very involved process, and he's known cases that have been unresolved for years.
Yeah.
Matter of fact, sometimes when I drive past properties uptown and see them like in a certain condition for years and years, I just know it's a problem with ownership.
Yeah,
Right?
and the truth is too, because back in the day, the reason I was even praising the Supreme Court, the probate division for 6 months of grants, back in the day, it used to take so much longer to get these grants, so much longer. So I saw somebody saying that, wow, 6 months to 8 months is very long to get a grant. No,
They're doing well.
They're doing so much better now.
Yeah.
They're doing
Guys,
so much better.
oh yeah, man. So what I'll do, so we have quite a few more questions from YouTube coming in. I'm just asking if you can stay with us for about 10 to 15 minutes while we get through them. But we certainly will have to do our part two. This conversation is so good, and I think so we haven't spoken much about life insurance, but Courtnay, it's very, very important, and certainly the will process is important. And these are the conversations that we don't have very often. And even when we talk about generational wealth, it's usually on the building wealth side rather than the build and transfer wealth side. Because I mean, in more developed countries, this is big business. They call it generally estate planning, where people start planning their estates to even their grandchildren, right? So there are skip over clauses. I mean, so we know that
Yeah,
there's
do your research, man.
what study a liquor thing. It was just on one page. That was just on one page, But yeah, man. Dennis said he's loving the discussion. Thanks, Dennis. I'm just trying to go through the questions. In the case of a will, so people will have questions about tax efficiency. And I think, well, from my perspective on the finance side, I would say for as it pertains to tax, you should get your tax advice.
Yes,
Thank
please.
you. Yes,
Please,
indeed.
yes.
Yes, we
We're
don't
not
want
tax experts.
and I'm not either, so I don't want to say anything here and you go down at the TAJ and say, Jaavonne.
Thank you. Do not.
She's an attorney at law and she said that this is how it's done. No, don't
And
want
that's
that.
what guys. This is general information,
Not legal advice.
Not legal advice. And so your specific scenario, please take it to an attorney at law, and they will duly advise you as to the specifics of your particular circumstance. Right? So we have to plug that there.
And you can reach out to Jaavonne and Courtnay on their socials. So Jaavonne is White Glasses Chick, I believe.
Yes,
and that one is easy to remember. And Courtnay is Miss Boss.
Yes.
Miss _ Boss. Yeah, man. So Trevon is asking, suppose information on my life insurance and will conflict, which has the greater enforcement?
Remember what we said about the life insurance, it is separate and apart from what forms part of your will in most cases, right? I'm speaking generally now. For the beauty of the life insurance is that you are able to appoint your beneficiary, and that beneficiary has the benefit of the payout upon your death, separate from your estate and the things that can be transferred under that will.
So you don't have to. So you really don't have to. So the persons who you leave as your beneficiary under your life insurance policy don't have to be the persons that you leave as beneficiaries under your will.
Right.
So there is no requirement that you do that. But certainly, if you have children, persons usually say, put. The recommendation is that you make provisions for your children.
Provisions for
Okay.
So Shani Body is saying, excellent. These ladies sound passionate about this subject. Love it. Do you guys go into organizations and colleges to share this wealth of information?
Certainly,
come set that up, man, because this is very important.
Well, if you want us, we are here. Honestly, seriously, I am open and willing to have conversations about this, and not just this, but any other legal topic that I'm able to speak on. And if not me, certainly we have colleagues that we have access to, that we'll be able to sit down and have a conversation with.
And I want to say that we take our lead from Investment Twitter, because we have learned so much from you guys that we say, as attorneys in the space, young attorneys, let us, follow suit and share knowledge. So I know Jaavonne is passionate. I love to help young people. I think we're doing an awesome job in terms of learning and growing.
And
so I'm definitely open to doing presentations.
I wanted to plug that finance professionals don't usually back in the day wouldn't have normally spoken about finance topics online because they didn't want it to be misconstrued as advice, because there are rules and laws surrounding that. And I always wondered why lawyers don't do it, but just hearing the hundreds and thinking about the possible hundreds of permutations of how things can go, it's kind of the same thing.
Yeah.
You don't want somebody to leave here and say Courtnay from XYZ said this.
Exactly. Please don't, guys. Please.
Yeah, and that's the truth, because as I said, I keep saying it, life is dynamic and your situation is very unique. So I'm on a program here just giving general information. I don't want you to take it and run with it, and then you can hear that I follow what Jaavonneztaylor said, and Jaavonne tell me this, and this is wrong advice. So like like financial advisors in that space, we have that as well. We have to protect ourselves.
I see a comment here, Simon. How am I able to engage you to help in presenting to a community? I could just leave my email address. Jaavonne could do the same. Yeah. My email address is Courtney_Patterson, PATTERSON @hotmail.com. You can always email me.
Right. And mine is Jaavonne. So it's JAAVONNEZ Taylor@gmail.com as well. So and as Simon said, you can find me on social media as a White Glasses Chick. I'm on Twitter. I'm on TikTok. I am on, what is the other one called? Instagram. Sorry, guys. Getting old. So I'm there. So you can send me a DM.
Yeah, ma. We have a question from Richard Gordon. I'll put it up. So he came on late, but explain how someone's will operate when someone passes away and who has named different beneficiaries on their pension account. So the beneficiaries on their pensions account at say a Barita or Proven is different. So does pension form a part of your will assets?
That's a good question. I would want to reach out to somebody with a little bit more knowledge on the pension side, and I would get back to you on that one.
Right.
Okay.
I don't want to misconstrue.
Yeah.
Yeah, man, no problem. So I guess this is from the professional side. Heron is asking, can you help to set up a trust or holding company?
All right, so that is not me. That's not my area of expertise, but we can put you on to the relevant personnel who can help you set up the trust or the holding company.
All right, Heron. So I like where your mind is in Heron.
I love it too.
Yeah, man,
these are the questions and these are the things that we need to be thinking of now.
Oh well, already when
that one.
Yeah, man. Richard, again, suppose I get a will properly executed from one of these lovely ladies, and I migrate and get citizenship in another country. How does that affect?
It doesn't affect it. It doesn't affect it. The only issue is that if you go and acquire other assets in another jurisdiction, you have to be careful that if you're creating a new will in that jurisdiction, that it doesn't revoke the will that you would have already created here.
Again, that's why I say if you have peculiar circumstances like this, speak to your attorney.
Right.
That's an interesting point, because I remember Courtnay, what one of you would have mentioned that when you create a new will, it kind of revokes the last will.
Right, because there's normally a clause that says this will revokes all previous will.
And even if there is no clause, even if there's no express revocation clause in the will, the law is that the newer one would have revoked the former.
Yeah.
So you have to be very careful.
So if in the newer one, let's say I go to Canada and I migrate to Canada, get full citizenship, and I have a new will in Canada, and that will list my assets in Jamaica, can it do that, or is a Canadian will for Canadian assets?
It can, but here's the trick. You have to ensure that the will that you execute in Canada not only not only satisfies the laws of Canada, but also satisfies the laws of Jamaica. Because remember now, different jurisdictions may have different requirements for how a will be treated and how a will be valid. But let's say, for example, the will that you created in Canada is valid in both jurisdictions. What you usually do after you pass away, you get the will probated in Canada, right? Once it's probated in Canada, then that very same will is sent back to Jamaica and it is resealed. To deal with the Jamaican assets. Right?
All right. So, well, it looks like Richard is doing some family, he's doing some family planning, So another quick question for everyone: if two persons set up a will individually and then get married, what happens to those properly executed will documents?
Marriage just revokes it.
Yeah, marriage revokes all previous wills.
So you just make another one.
Yeah.
Yeah, Richard. So you're going to need to make another one.
But funny enough, I thought he was going somewhere else. I've heard, and people have done this before. People have created joint wills. I've seen it where people have created joint wills. It's not something I recommend, but persons have done it. I have, because sometimes they have all of the assets are joint. So I've seen older people who have joint bank accounts. So all the assets are joint. So joint bank accounts, their names are jointly on the title. Their names are jointly on the car. So what they've done is created a joint will. Right, and what they've basically tried to say is that, so it's the will of Jaavonne and Courtnay, right? And it basically says
when we both pass, what happens?
Right. It says when we both pass, what happens, or it says if I pass away, then everything goes to you, and then whatever. Or it says, so obviously based on the whole joint tenancy thing, as we were explaining before, if we both own things jointly, then it is automatic that it's gonna pass. But then it also contemplates what's gonna happen. So if I die if I die last, then this is how my estate will go. But if you die last, this is how the estate will go, right? Because you don't know if you're going to go before me. But to be honest, I don't like them. I don't recommend them, but people do them. So we're just letting you know the options that exist.
Okay.
I think this question here, would you need to prove they were in fact in sound mind? I think
this,
that was
this was related to the one before.
Yeah.
I think we answered that.
Jaavonne would have spoken about
that. We did. Okay. So what I'll do, I think we've reached at the end of the questions. However, someone said they love this. They're waiting for part 2, because there is more that we can speak about, probably in a bit more detail, and we didn't even reach the powers of attorney.
No, we didn't even talk about the duty of the executor and how important it is to really make sure that the person you use consents to it and understands the implications as well. Because you just don't want to choose any random person to be an executor,
And then there's the other one. I've seen it in movies. Sorry, I watch a lot of movies.
That's fine.
Where if something happens to you and your wife, you can choose who takes care of your children.
The guardian.
Yes. So there is so much more that we have to talk about, guys. But we are out of time. What I'm going to do, Jaavonne and Courtnay, is that your contact information that you've shared. Some people said they would have missed it. So what I'll do is I'll place it in so one, you can DM us, or and I'll place it on our socials, if you so please. Remember guys, thanks a lot for being here, audience. Thanks a lot to Jaavonne and Courtnay for taking out their time. It's Sunday. I know you're preparing your cases for the week and everything, so I know it's but I want to also encourage people to follow Stocks on the Rocks on Twitter. We follow the channel on YouTube now, so I'm going to pause for 3 seconds and you just click subscribe. On the bigger channel is a point at a certain spot, but I don't know where that is. So you can subscribe to our YouTube. We're gonna have a lot more great content. Look out for our part 2. People are asking about the Telegram group. If you already have Telegram, you can search for SOTR community on Telegram, and you'll see the group pop up. It has a yellow badge, and you can join. We talk about investments almost every day at any hour. You can ask any questions you have there. Any questions about wills as well, because we do have attorneys in the group as well, and I'm encouraging our host, our guests here to join as well.
We
But
will.
thank you so much. Thanks everyone behind the scenes that has helped in creating the flyer. Jaavonne for assisting in the moderation. This recording will stay on YouTube, so you'll be able to go back and pick out from it's a lot of information, so you can pick from that. Remember to like the video before you leave. It really helps us. So giving you 3 seconds, like the video.
Like it, guys.
Like the video, guys. I've always wanted to do that, by the way.
So thanks a lot again, Jaavonne and Courtney. Thanks to
Thanks
the
so much for
audience.
having us.
Thanks for
Yeah,
having
man.
us. It's been our pleasure.
All right, bye guys.
Bye.